Hello everyone. Welcome to Karmyogi IAS. Welcome to the session on quick revision of Indian polity. So in the last session, we discussed about compassionate appointments and its relation to DPSP. In the current session, we are going to discuss about one of the very important concept, that is Office of Profit. As you all must be knowing that elections are also going on in the country. Side by side, every now and then we have had this discussion about the concept of Office of Profit. Questions have also been asked in the examination, and there are chances that questions may be asked again in future. And this year's prelims examination, the concepts which are related to parliament, parliamentary privileges, rules, and all become very important ultimately, considering the fact that this is an election year. Okay, so we are going to discuss another particular topic which is very, very essential, Office of Profit. So without any further delay, let's begin. So this concept of Office of Profit, first of all, you need to understand it relates to positions held by members of parliament or the members of legislative assembly. Means they are generally discussed in the context of MLAs or MPs, and it relates to any financial gain arising out of it. Okay. The term originated in English Act of Settlement in 1701, hence the concept of Office of Profit is borrowed from the UK. So this kind of question may be asked in the exam. If you are asked from where the concept of Office of Profit has been borrowed in India, you will say it is United Kingdom or Britain. Okay. The Constitution and RPA, Representation of People Act, does not have a clear definition of what constitutes an Office of Profit, but it has been developed through various court judgments. So be very, very clear about this. I'm again repeating, if any question statement speaks that Office of Profit has been mentioned or has been defined in the Constitution, has been mentioned or defined in any law, then it is incorrect. So please keep a note of the word mention or defined. It is nowhere mentioned nor defined in any act, any law, or in our constitution. However, it has been developed through various conventions and Supreme Court judgments. Okay. Now, what constitutes or what is an office of profit? So, as I told you, from Supreme Court judgments, it has been brought forward. So, in Pradyut Bordoloi versus Sopan Roy case, 2001, there was a criteria set by the court, or we can say a test set by the court, that in order to understand or consider an office to be an office of profit, multiple factors has to be taken into account. Now, what are those multiple factors? First of all, whether the government is responsible for appointing the individual. If yes, then that is coming under office of profit. If the government has authority to terminate the appointment for a particular post, then that is an office of profit. If the government sets the remuneration for the position, what is the source of remuneration and extent of power authority associated with the position? So if an MP or an MLA is holding any such position which is satisfying these particular factors, then that office will come under office of profit. Means an MP or MLA, if they are holding the office of members of parliament or legislature, cannot hold any office that satisfies these conditions which I told you just now, because then they will be considered to holding two office at the same time and getting double the benefits from government at the same time, which will be violative of our constitutional provisions. Okay, so this has to be clear in mind. Now, what are the constitution and legal provisions not pertaining to office of profit, I would say, to be more precise, that may indirectly affect this concept of office of profit? Then Article 102(1) is there. A person will be ineligible to be elected as MP if they hold any office of profit under Government of India or state, except for those offices that have been declared by law to not to cause disqualification. So exceptions, if given in any law, if mentioned in the constitution, then they'll not be categorized as office of profit. Now, I'm very sure that many of you might be getting this confusion in your mind, that just now sir mentioned that office of profit is nowhere defined or mentioned in the constitution, then why the legal and constitutional provisions? So, my dear aspirants, be very, very, very clear. I told you that it is nowhere mentioned or defined in the constitution. When I say mentioned or defined, that means that the office has not been described anywhere. Okay. The word is there, but what constitutes office of profit? What positions will be coming under office of profit? How to determine office of profit is nowhere mentioned or defined in the constitution. So be very, very clear about it. Okay. Then Article 103 also deals with this. If a question is there whether a member of the House of Parliament has become subject to any disqualification under Article 102, the question shall be referred to decision of President of India. Any decision shall be final. Then President shall obtain opinion of Election Commission before giving any such decision. This is another article that generally deals with the concept of disqualification and office of profit. Similarly, Article 191, Clause 1, it relates to office of profit under government of a state. Okay, other than the office declared by legislature of a state. So it relates to MLAs, and Article 102, 103 relate to MPs. Be very clear about it. Then there is a law, Parliament Prevention of Disqualification Act 1959. It has been amended multiple times to expand the list of offices that are exempt from disqualification. Minister of State or Union, Leader of Opposition in Parliament, Chairman of National Commission for Minorities, National Commission for Scheduled Caste, National Commission for Scheduled Tribe, Women, etc. Chairman of NHRC, all these. Okay. So, Parliament Prevention of Disqualification Act mentioned some of the offices that are exempted for disqualification under Office of Profit. Then there are certain state laws where state governments have passed the laws to exclude certain offices from being considered an office of profit under state jurisdiction. Okay. Now, in this context, I am going to go a way forward and discuss why is this office of profit a ground for disqualification. The concept is that suppose a member is already enjoying all the benefits as a functionary of a state legislature, judiciary, or executive, then if he is holding any other office, there are chances that the individual might come into conflict of interest. So, to ensure separation of power, it is very, very important that a person should be debarred from holding two offices at the same time. So, office of profit means suppose MP is there. Okay. That particular MP is also holding a particular position in his constituency or in his state, any office in his state, where he has to perform duty in official capacity. Suppose a person comes to him, coming to him taking any tender, for taking any contract, then there might be conflict of interest that the particular MP might be obliged to provide that particular individual who is known to him to that particular tender or contract. So these kind of things might impinge upon constitutional morality. That is why office of profit concept is there. Upholding the constitutional responsibility. This is also very, very important because a member of parliament is representative of the people. They are bound to uphold the constitutional duties and responsibilities. Again, I told you separation of power to ensure check and balance. A person should not get dual benefits, preventing conflict of duties and interests. So these are the rationale for conflict of interest. What are some of the Supreme Court judgments we'll see? Because many a times questions about Supreme Court judgments also come in the examination. So it started in 1964 in CVK Rao versus Detu Bhaskar Rao. Supreme Court Constitutional Panel ruled that mining lease does not amount to contract of supply of goods. Similarly, Kartar Singh and Hari Singh Nalwa and others, Supreme Court made it clear that mining lease does not amount to execution of work undertaken by the government. So you don't need to remember all these nitty-gritties and important details about the judgment, but yes, the case name you should know. Suppose it comes at Kartar Singh Bhadana versus Hari Singh Nalwa and others was related to which of the following cases? Okay, right to privacy, right to life, okay, right to live with dignity, right to environment, office of profit. So you people should be striking the correct answer. In Jaya Bachchan case, the court held that office of profit is an office that is capable of yielding a profit or pecuniary gain. The actual receipt of profit is not necessary, but potential to yield the profit is sufficient. Means even if a person is not deriving tangible gains or evident gains from that office, but he or she is holding that office that has the potential to provide profit in the end, then also that will be considered as office of profit. Then there was UC Raman case where the court held that Constitution allows the legislature to pass a law to grant exemption to any office of profit. Then Calcutta High Court judgment in 2015 stated that appointment of legislators as parliamentary secretaries is an attempt to bypass the constitutional limit on the number of ministers, as it confers the rank of junior ministers on the legislature. Similarly, Bombay High Court also held that appointing parliamentary secretaries of the rank and status of cabinet minister is violation of Article 164. Okay, so from this we come to a conclusion that parliamentary secretary is also coming under office of profit. They are not exempted. So what is the way forward in these kind of things? First of all, we have second ARC recommendation. Okay, it is stated that either our constitution or Representation of People Act should be amended to define office of profit, as it is not defined. Then it also said that all offices with executive decision-making powers and financial control should be treated as office of profit. So, but this is a far-fetching decision. This should not be implemented, in my opinion. Then Parliament's Joint Committee on Office of Profit has suggested additional parameters like remuneration, powers, patronage to determine the office of profit. Then there was Venkat Chalaiya Commission, National Commission to review the working of Constitution, which suggested that Election Commission should be mandated to determine office of profit. Okay, these should be the way forward in this case. However, this is not going to come in the prelims exam, but you should be well aware of these pointers to quote in the mains exam answer writing. In 2019, we had a question in prelims. Consider the following statements. Parliament Prevention of Disqualification Act, we discussed just now, exempt several posts from disqualification on the ground of office of profit. Yes, this is correct. We just now discussed it. Look, this particular section. Okay, to exempt from disqualification. Okay, so we discussed, and this kind of question came in the exam also. So you people should be well ready for these kind of questions to be asked. Second statement, above mentioned act was amended 5 times. Yes, it has been amended multiple times. That is also mentioned. The term office of profit is well defined in the constitution. Extreme statement, well defined. No, this is wrong. It is not defined, not described, or not mentioned very well. So only 1 and 2 are correct. Okay. So I'll summarize once again. We discussed in the session about office of profit. It relates to which particular authorities or constitutional functionaries. We discussed about from where it is borrowed. We discussed the factors determining office of profit, some legal and constitutional provisions dealing with office of profit, and ground for disqualification. I quoted some of the Supreme Court judgments, which you should be aware of. Don't go into the detail of the judgments because it will not be asked, but you should have a reference that if these judgments are coming, they are relating to which particular concept. So that in prelims exam, if a question comes or a statement comes, you can be able to mark the correct answer. Then we discuss the PYQs. Okay. So with this, we come to conclusion of the session. Go and revise about office of profit. Go and read about some of the disqualification and qualification provisions for the MPs and MLAs as given in your book and notes. Until then, all the best. We'll meet up in the next session. Hope you all are good. Have a good day.